Look at these 3 words written larger than the rest, with a special pride never written before or since. Tall words proudly saying, "We the people."
Welcome to the Lex Rex Institute podcast. I'm your host, David Truschel, the lead writer for the Lex Rex Institute.
And I'm your co-host, Alexander Haberbush, president of the Lex Rex Institute and a constitutional attorney, though I will not be speaking in that capacity today.
Before we begin, please note that nothing in this podcast constitutes legal advice, and all of
Really?
the opinions expressed are the... Yes, really. And all of the opinions expressed are the opinions of the individuals expressing them, not necessarily the opinions of the Lex Rex Institute.
The Lex Rex Institute is a nonprofit constitutional advocacy organization. If you'd like to learn more about our organization's activities or make a donation, you can visit us online at www.lexrex.org. Should give the HTTPS along with that too, just to make David that much more annoyed.
No, you shouldn't. Yeah, don't do that.
No?
You probably still put 2 spaces after a period too, don't you?
Anyway, I take the fifth on that one.
As a reminder, this podcast is a legal issues podcast, not a political issues podcast. We try to keep our commentary strictly to legal issues, and today, now that more issues than ever are considered political, we believe it's especially important to distinguish those.
Yeah, our name is Lex Rex. That's Latin for the law is king, because that's the only king we got in America. You know, other countries, they have kings. America, we don't. Our only king is the Constitution, so we're dedicated to upholding that.
We've got one big topic for this episode. We're going to be continuing our series on the early stages of the American Republic and the French Revolution. But before that...
Anyway, before we jump into that Summer of the Revolutions issue, I did want to talk about one of our new cases. So this is actually a case that's been gestating for quite a while. We just filed our lawsuit today. Our lawsuit includes a petition for a writ of mandamus because the Los Alamitos Public School District... Well, I'll give you a little bit of context here. Every year, Los Alamitos Unified School District sends its 5th grade students to what they call an outdoor science camp. And in the past, science camp, you've learned about sciencey things, outdoor things, about plants, trees, I don't know, whatever. I'm not a scientist. Whatever science happens outside, you learned about that.
And with 5th graders.
This year...
probably...
With 5th graders,
a certain set of things. You probably aren't going to be, taking core samples or, that sort of thing, but something.
Oh, that'd be fun. Although when I was in 5th grade, we learned about roller coasters, learned about, different forces of physics, and then just rode roller coasters. I'm not sure that we actually learned much from that at all. But anyway, science camp, they're supposed to learn about science. Only this year, unbeknownst to the parents of the Los Alamitos Unified School District, the science camp they selected was really more of a, how would you put it, David?
As we've learned in the course of this case, the company that ran this camp mainly specializes in running sort of adult-oriented LGBT retreats. So it was seemed like an odd fit. There, certain things that came out about the way they handled it didn't sit quite right.
But you can imagine. Yeah. But you can imagine the sort of if they're a pro-LGBTQ group, if their objective is educating people about LGBTQ issues, a bunch of 5th grade girls from Orange County were not necessarily familiar with or had previously been exposed to some of the ideas that they were taught here. I guess you could argue that there's science of a sort. Certainly not what the parents thought they were getting into when they sent their daughters here.
Yeah, and maybe they did some science stuff too. I'm not sure based on the records that we've seen.
It doesn't sound like they did a whole lot, but they might have. But anyway, they were exposed to all sorts of things. Gender identity pronouns, they, them pronouns. From what I understand, a large proportion of the counselors here identified with themselves with they, them pronouns. They were confused. Like, are you a girl? Are you a boy? Well, I'm neither. Let me tell you about gender identities. Yeah. You can imagine this should be fairly disturbing to people of particular political views. And anyway, it ended up being very disturbing to a lot of the girls who were at this camp. But to make matters worse, it's an overnight camp. And of course, 5th grade students have to be housed with counselors in the dormitories there. So these girls who had just been exposed to these ideas about preferred gender pronouns, so on and so forth, ended up being housed in dormitories with counselors of indeterminate gender. Yeah. Now, some parents might have been fine with this. I don't know. Some of the kids might have been fine with this. I don't know about that either. What I do know is that a lot of kids were not fine with this, and when the parents found out, boy, were they not fine with it. And really, I can't say that I blame them at all, because people who are not exposed to these ideas, it's obviously going to be very traumatizing to hear that the person who's in your room might be a man if you're a 5th grade girl. Because they don't know. They had no idea. So parents ended up finding out about this quite a bit later, actually. The daughters are so traumatized, they don't talk to the parents about it for quite a while. My client, the lead plaintiff in this suit, we have several clients in this suit, but one of the lead plaintiffs, she doesn't find out about it till 10 days after it took place because her daughter was so traumatized. At that point, parents start trying to put pressure on the school district to tell them, why did you pick this place? Why did you think this was a good fit for outdoor science camp? And if you thought it was a good fit, why didn't you tell us the sort of camp it was? We thought it'd be like it was in the past.
Yeah.
School basically stonewalls them.
Right.
Among other things, they want to know where our daughters housed with biological men. School tells them that they are legally barred from answering that question, and then stonewalls on it for about a month. Although at the end of that month, they actually do answer, and they say, no, we're pretty sure that none of the girls were housed with biological men. So if it was illegal to say something, I don't know how the heck they ended up saying it later. Sure sounds like just sort of an excuse for hiding things from parents. It might be worth teaching these sorts of issues to school kids, but certainly not without parental notification and consent, which is what happened here. So we requested a number of documents from the school district. They have given us responses to those document requests that are woefully inadequate. We know for a fact there are documents responsive they did not produce. So we have filed a lawsuit against them in state court, and we are going to make them answer for what happened and provide an account of why they chose this institute, and then seek damages for the harm that they've caused to these girls and to the parents by failing to notify them.
And, I want to underline, too, the reason why this is an important issue to us as an organization is really not to do with the sort of specific political angle or whatever else that's going on here. It's about the rights of parents to understand what's going on at their kids' schools and the duty that schools have to be open with parents. Legally, they in fact do have to answer your questions as long as they're not improperly disclosing private information, that sort of thing. You can, we've talked about PRAs before. The public has a right to access records of public institutions, and that's the fundamental legal issue at play here.
Yeah. I mean, there are probably other legal issues down the pike as well, including, negligence, deprivation of parental rights, and all sorts of things like that. But at this point, this stage in the dispute, we just want to know what happened and why.
Yep.
And they're refusing to tell us that. So that's what we're trying to obtain. David's right. It's not about the particular thing they were teaching. If there'd been an outdoor science camp where the main thing that they were teaching about was how guns work, and they were putting guns in the hands of kids, and kids were using those guns, and then a group of parents told us, we're not comfortable with our kids using guns, that'd be a lawsuit that we would bring too. So it's nothing about the political angle here.
Yeah. Anyway.
It's personally, they could be teaching kids stuff that I think they ought to teach kids, but parents have a right to determine whether, if their kids are being taught something, and certainly to know what's being taught to their kids.
Yeah,
so
and especially,
it's not a matter of agreeing or disagreeing with the content.
Yeah, and especially in a situation like this where they were given, because I've seen the information that the school provided before this, they were given pretty minimal information about what was going to happen, and sending your kids away for an extended period of time without their phones, that was part of it too. They couldn't contact their parents.
They were very uncomfortable and had no means of contacting their parents.
Yeah, and, a parent has every right to have, as much information as they would like about that sort of situation.
So what we've done is we're actually taking this case free of charge for our clients, but that doesn't mean free of charge for us. It costs us quite a bit to be able to bring cases like this. And if we don't get contributions from you guys, we'll probably go bankrupt, not be around all that long. But, we do count on the generosity of the public, and we know that people care about cases like this. And we count on people to support parental rights in an educational context like this. So we have set up a Give, Send, Go page where you can donate to our campaign. The URL for that page is, let me find it here 1 second. Oh, that's not too useful. It's a Give, Send, Go /G3PCB ? Share SMG equals display. So that really easily memorable URL, you can donate to our campaign. We will change that URL to something much more memorable. Maybe Give, Send, Go /Los Al or something like that. But anyway, we'll link it in the description. You can access that Give, Send, Go page. Really, we are counting on contributions for this one. That's going to be funding the entirety of this case. And there's going to be a lot of legal work involved on this. So, we're counting on the generosity of the community.
for the record, just the G3 PCB part will get you there. So, but either way.
Well,
either
so then
way,
givesendgo.com/G3PCB.
Yeah, not super memorable anyway, and we will definitely provide a link, and maybe we'll be able to change it to something catchier.
We'll probably
later.
change it.
But
all
anyway.
right, so that's all for that. So I want to let you guys know about that. That was just filed earlier today. So that is a huge lawsuit. It's actually why this podcast is coming out a little bit late, because we record these ahead of time, and I didn't want to make an announcement prematurely. So we apologize if you're listening to this later than you usually do. But without further ado, we do want to get through our material we have for the day. We've got an exciting program for you guys. Next, we have on our agenda how the Constitution of the United States addressed the failings of the Articles of Confederation. David, didn't we already talk about this?
Well, we talked about the failings of the Articles of Confederation, but I'll sort of...
And because I love the Constitution, I just couldn't help but talk about how it did it better.
Yes, basically. But anyway, to sort of peel back the curtain a bit here, we've been trying to keep the sort of the episodes about France, the episodes about America, sort of symmetrical with each other. So the last time in each of those episodes, we looked at the first attempt that those countries made to get a new political order in place after upsetting the apple cart, in our case, separating ourselves from the Crown of Great Britain. In the French case, killing their king. A little different. But now we're going to look...
Wait.
Thank you. Yes, that is indeed what happened. That could very well be a recording from the death of King Louis. I don't know whether they had that or not.
I think you're a little early on that one for the invention of recorded sound.
I don't think so. I don't think so. It's all
no?
It's all the same, right? Back in the day.
Wasn't it Edison that invented that? Was he? I don't think he was around then.
No. I think it was actually Dr. Guillotine.
Dr. Guillotine did it. All right. Wait, he was a doctor that invented the guillotine?
Actually, I found this out because I mentioned this on one of the past episodes. I am currently reading a book about the French Revolution. His name was actually...
Oh, there's another point of feedback that we got, David. You're supposed to mention the name of the book when you say that you're reading something.
Right. I think... Okay. Oh, shoot. My Kindle's not with me. It's like the Oxford History of the French Revolution, something... I forget. I'll find it for next time, or maybe we'll put it in the description.
You put it in the description. Yeah.
Anyway.
We want people to be able to read that along with you, David. That's part of the fun.
All right. It's a little dry, so people looking for a sort of gripping narrative history aren't going to find it.
That was the other feedback we got, is that you're boring.
Yeah.
We got a lot of comments saying that, David.
I'm aware of this, first
yeah,
of all.
What our listeners don't understand is that's why we picked David.
Yeah, no, someone has to be the straight man in the pair, and that's me.
Yeah, I'm the straight man all week. I can't do it on the podcast.
Yeah, fair enough. Anyway, actually, as I learned from this book, the namesake of the guillotine, his name was Joseph Guillotin.
Less boring, David.
Anyway, not guillotine, but it was named after him, so guillotine. He didn't invent it, but someone proposed the idea to the National Assembly, of which he was a part, and he sort of supported it. He was, in fact, a medical doctor, though. That is
Wait,
true.
so it's the guillotine resolution, then?
Basically, yeah.
Huh. Who knew?
Yeah. Anyway.
He said, like, I'm going to put my stamp on that because that's actually something that's worth noting. The point of the guillotine, like a lot of different other things that were created during the French Revolution, was to be a more rational means of accomplishing the goal. I should be playing the sound effect. Yeah, there we go. But
basically it's
no, I'm gonna. But the idea was that it was a less painful, quicker, really more, I think, to describe it sort of pejoratively, a more sterile way of executing somebody. Which, of course, there's real reasons why you don't want to do that. You want a death penalty to be fairly heinous so that you don't use it often. I don't mean cruel and unusual punishment. People can take that totally the wrong way, I'm sure, that we should make criminals suffer, so on and so forth. But, but you don't want it to be something that is clinical.
Yeah, you don't
you
want
to be aware that what you're causing is death.
Yeah, you don't want it to feel, well, I guess this is sort of a pun, but bloodless, so to speak. And,
Oh, it was far from bloodless and guillotine.
Right. Yeah. Oh, my gosh. All right. Anyway, I think that the part of the sort of detachment that you're getting at is probably why they felt so comfortable sentencing people to the guillotine. And that's a negative side effect of it. To be fair,
it's easy.
If
you're a headsman that has an axe and you have to swing that, I feel like it's a lot harder to make yourself actually swing that axe than it is to pull a lever.
Yes, that's true. The downside there is very often executions by axe weren't particularly
Yeah, we're not
quick.
proponents of execution by axe here at the Lex Rex Institute.
So sometimes it took far too many swipes to actually, finish the job. And
I'm not saying that execution by axe is better. I'm saying that as the rough equivalent, something where you have to look the person in the eye and you have to actually do. This is getting really gruesome.
Well,
let's move on. Let's talk about the Articles of Confederation.
Anyway, well, right. So anyway, to return to the point here, we're now going to look in the next few episodes at how America moved on from its sort of first failed attempt versus how France did. And, it went, I think we can say pretty conclusively, a lot better in America. And with that, let's get into... How did that even connect? I don't understand.
Oh, that's showing how it didn't go better in France.
If you say so. Anyway, so we're not going to talk about the Constitution as a whole. That's too big of a topic for one thing, and for another, we have to save some material for the future.
Yeah.
But
this podcast is about the Constitution, so every episode's about that.
In some sense, in some way or other. Anyway, but we did want to highlight a few specific areas, and the first and probably the most obvious is going to be in the way.
These are ways that the Constitution improved upon the Articles of Confederation. Just to clarify. Now, I do want to. So, do you want to jump straight into the ways it improved? I wanted to say, sort of what they were tasked with doing at the Constitutional Convention.
Okay, sure.
Okay, so this is actually the resolution that was passed, and it's that the Articles of Confederation ought to be so corrected and enlarged as to accomplish the objects proposed in their institution, namely common defense, security of liberty, and general welfare. So the purpose of the Constitution is to more effectively do the same stuff the Articles of Confederation was supposed to do. Yeah. Specifically, the three things it did very badly were common defense. So what is that? That's probably referring most specifically to Shays' Rebellion, but also the possibility of foreign war, also the possibility of civil or internal war.
Right.
Because there were a lot of disagreements between states, and they weren't entirely sure how those were going to end. Not to say that we managed to avert that under the Constitution, but we probably managed to delay it a bit.
A good long while,
we definitely delayed it.
Yeah.
That may not be the best effect. But anyway, we'll get into the better effects here. So security of liberty is another one. So what does that mean? Well, that means that not just having liberties, but having liberties that you are likely to keep.
Yeah.
Because a lot of the value of liberty is that you can invest on it, right? You know that the way things are today, they will continue to largely be like that tomorrow, or at least continue in the same direction, such that you can make decisions about your life without worrying they're going to be totally upset by huge changes in your circumstances. So that's security of liberty, not just liberty itself. And then lastly, general welfare. What does that mean? That mean welfare payments?
Yeah, I think so, right?
Yeah. So the new Constitution is better at welfare.
Yes. Mm-hmm.
No, I don't think that's what it means. General welfare is just sort of a catch-all phrase. It means, so here's two specific things we wanted to do. Better defend, you defend everybody, defend all the states in the Union, better secure the liberty of the people of those states and of the states themselves, and then just sort of generally work better. Yeah. Work toward the welfare of its members.
And, I think you see an echo of that in the preamble of the Constitution itself in order to form a more, perfect union. So it's, improving the existing thing.
Yeah, that's exactly right. So, often accused of sort of throwing out the Articles of Confederation, which is true. Structurally, they did throw out the Articles of Confederation, but it's not just, a replacement with a totally new, different system, the way that we got in France. It's trying to accomplish the same aims and objectives of the Articles of Confederation. So here we go. Here's another resolution. Resolved that the Articles of Confederation ought to be revised and amended so as I didn't put a space there. I put torrender, so as to render the government of the United States adequate to the exigencies, the preservation, and the prosperity of the Union. Sort of a different way of saying the same three things. So exigencies, that means unexpected circumstances. Emergencies, that'd be the common defense one that we talked about in the last group. We talked about this a lot last week, how emergency powers are kind of BS. Because our Constitution was made to be able to deal with emergencies. You shouldn't just say that state of emergency now, so we're suspending the common social order, like the Korematsu decision did. So next we've got the preservation. That'd be the same as securing liberty, a preservation of what we have, and then prosperity of the Union. So general welfare, again, prosperity, just making sure everybody does well. That's probably most specifically targeted at financial matters. So the fact that you can't fund the government under the Articles of Confederation. You can't get foreign countries to invest in you. The national government has no credit under the Articles of Confederation. So I think that probably general welfare and prosperity of the Union have to do with that. So those are the goals. Now, how does it do it?
Well, first, probably most obvious way, because we really hammered this pretty hard when we talked specifically about the Articles of Confederation, there was no actual executive under the Articles of Confederation. It was, sort of executive powers.
In fact, there weren't even 3 branches of government.
No, true. Basically, just
there weren't
one.
really any branches.
Yeah,
Articles of Confederation is about Congress.
Yeah, there was just the government, and it was essentially Congress. Yeah, but very different than our Congress. We'll get to that later. So
separation of powers ends up being a huge feature of our Constitution.
Yeah.
And sort of the motivating factor for that is the need for an executive.
Right. But the reason they probably didn't want an executive to begin with, they were afraid of what can happen with an overly powerful executive. So how do you solve that problem? You balance powers. And one of the key ways they did that is by separating the executive from other branches of government. So
they'd seen a couple overly powerful executives before, hadn't they?
Yes, and throughout history,
like the military governors of Massachusetts. You thought I was going somewhere else with that, didn't you?
No, because we've talked before about George and his role in the whole thing.
Yeah, George was a tyrant, but I don't think he was the one that they had centrally in mind when thinking about tyrannical executives, because he was pretty far away. He was thousands of miles away.
And it's become such a common misconception, I think, about one of the common misconceptions I think about the way that's taught is that, we decided monarchy was tyranny and monarchy is bad, blah, blah, blah. That's not at all what happened, up to and including the fact that we seriously considered having a king in the U.S.
In fact, they begged Washington to be king.
More or less, they even thought about inviting foreign nobles to come and be the king of America, like that. Anyway.
One thing that is probably the least new thing in American politics is that everybody hates Congress. Everybody hated the Congress even during the War of Independence. Everybody hated the Congress during our early American Republic. They always hated them, and people always say, we really like this one guy. And back then it was Washington. Pretty much 99% of the population agreed that he was the guy that should do it. Everybody said, you ought to just take over. You ought to make yourself emperor like Napoleon did over in France, although that hadn't happened yet.
But spoiler alert for the next episode about France. Anyway, all that to say,
it's a great letter Washington has where he talks about that. He responds to somebody who was urging him to do it, and he's just like, I don't know where these rumors started that I would have any interest in this. I don't know what I've done that would lead you to believe that I would do that. Please never mention this again. I'm going to be forced to punish you.
Anyway,
one of his soldiers. That's you can punish soldiers. It's not just him.
Yeah, not just like a random guy that he was threatening to come over and ground or something. But anyway, all that to say, the issue was never about kings just being sort of innately powerful executives. That wasn't what it was about. It was about specific forms of tyranny. Anyway, the problem is you
need an executive. How will
the
the executive help with the problems in the Articles of Confederation?
Well, for one thing, you have a guy who's responsible for a lot of things that would otherwise have required, a supermajority of states, generally speaking, to get a lot of important stuff done.
Yeah. And even then, who implements it? It's pretty much the state executives that have to cooperate to implement it.
Yeah, and we highlighted specifically the issue of the states in general had to approve any given state receiving an ambassador from a foreign country, and there was no one else who could do it because there wasn't a federal executive of any kind. States had to be the ones to conduct foreign relations, but they needed the approval of all the states to do so. That's not the way it works under the Constitution. Under the Constitution,
they also had that really Byzantine way of commanding the armed forces under the Articles of Confederation. So putting it under one guy makes a lot more sense. And the proof of the concept ends up being proven right away because the Whiskey Rebellion, in many respects similar to Shays' Rebellion, ends up ending totally different, where Washington is able to actually do something about it.
Right, and that's an important thing to be able to do, to respond to.
It doesn't make it, you don't look real good in front of the other countries at the playground when you have insurrections and uprisings in your country and everybody just kind of sits there and lets them happen.
Right. Yeah, it's not a good look. And that's not the only reason it's important. It's not just about showing off and looking good. It's also, you don't
not even primarily about that.
Yeah, you don't necessarily want any given single unpopular decision in your country to result in a massive armed rebellion. That's not an ideal state of affairs.
Yeah, and they point out, because I guess I'm jumping ahead here a little. Is that enough about the executive? Do we want to move on?
I think so. We're trying to keep a quicker pace, so yeah, I think we can wrap it up.
I guess sort of the takeaway from that, people like to complain about the increase of the power of the presidency, and we're definitely with them to a point. Lex Rex Institute is with them to a point. President should never be exercising legislative or judicial authority. We think that it is totally out of bounds for him to do that. That's a violation of separation of powers, and we will absolutely litigate those issues. President ought to be exercising executive powers.
Exactly.
And all too often they do not do that.
Yeah.
So we're in favor of a robust presidency in terms of executive powers. We just don't think that he should take other people's powers, because we, the people, have not delegated those powers to them.
Right. Yeah. Within the bounds assigned, we want every aspect of the government to be as vigorous as it wants to be, as vigorous as it can be in many instances. But within those bounds, that's the key point. Well,
I don't know if I'd say as vigorous as it can be.
Well, fair enough. But, you should do the
difference of opinions. People have differences of opinion in Lex Rex Institute. David
fair
is
enough.
in favor.
My main point when I say that is you should do the job that's assigned to you, and you shouldn't be lazy about it. But you should.
That's absolutely true. You shouldn't just say some bureaucracy is going to figure it out, because that's the way. Every time somebody proposes a law, say a law about what part can be on a car, all the congressmen say, "Well, I don't know anything about cars, but I know that we want to regulate them." Who does know about cars? A bunch of bureaucrats. So we'll have them figure out all the details, and then they pass that legislative power off to the president. We talked about that before in our episode on Chevron deference. I don't remember which episode number that was.
Well, we've talked about that several times, but anyway, yeah.
Yeah. So anyway, that's the power of the executive. That's sort of our takeaway from that. Don't just knee-jerk say president having power is bad. Right. President having power is actually very good. That prevents really the worst sort of legislative tyranny that Great Britain saw, and that really ended up imposing itself upon us under Lord North, where they would just pass a series of really draconian acts. Draconian, is that a word people know?
Severe. Yeah, that means severe or harsh or...
Yeah, really harsh, ridiculous, overbearing acts on the people of the United States, or I guess the American colonies at the time.
Yeah.
Yeah, you don't want that. Legislative tyranny is very, very bad. Anyway, next is going to be federalism, which demarcates a sphere of exclusive state power from federal power. So remember, under the Articles of Confederation, all power of the National Congress was derived from the power of the states.
Right.
So in strictest sense, it was not actually a national government, because it didn't have any of its own independent power derived directly from the people. It was just sort of whatever the states can agree to do. Articles of Confederation was not supreme law of the land.
Right.
And there were real disadvantages to that. So we're probably going to end up focusing mostly on the disadvantages today of not having a national government. But there's reciprocal disadvantages as well of having only a national government.
Yeah.
So federalism very delicately balances both of those things, because under the Constitution, the power of the federal government is derived both from we the people ourselves and from the authority of the states, from the state legislatures. It comes from both. Yeah. So it's got to respect the authority of both. And that actually leads into our next advantage of the Constitution, which is bicameralism, but that's getting a little bit ahead of ourselves, because remember, bicameralism is one legislature represents the people, other represents the states. But anyway, what are the advantages of federalism, David?
Well, for one thing, and we've talked about this issue before, but it allows for both local interests to have sort of their part to play. In the way that the Constitution is designed to work, the people of each state should have pretty, extensive local determination over things that they want to be the case, because the Constitution really doesn't afford Congress very many sort of arenas where it can make law. But it does have some, specifically where the states independently would be, wouldn't have a way to resolve issues. So
and interestingly, the vast majority of arenas where Congress can legislate under the Constitution are the same as they were under the Articles of Confederation. There's really only two differences. One is that Congress can now regulate commerce between states, because that's kind of necessary to actually have a national government, right? You want to make sure that there's some shared standards between all of them. And secondly, they have the power to lay taxes directly on the people.
Yeah.
Articles of Confederation could only levy taxes against the states. The Constitution of the United States allows for income taxes directly on the people. I'm sorry, I said income taxes.
No,
allows for
sorry.
direct taxes on the people.
Yeah, we needed to
And those
amend
taxes,
it.
as we've mentioned in the past, those had to be basically what we call a head tax. Each
Yeah.
person pays the same amount.
Yeah. There was an amendment that we needed to pass before we could start taxing income. But
Yeah. And the reason why it allows it to tax individuals is, again, the power of federal government's derived from the people. So it makes good sense that it should
Right.
be able to do that. The commerce power was sort of the controversial one. I would say that power was absolutely to be able to promote prosperity, general welfare,
Yeah.
because you need to be able to coordinate commercial activity between different states.
yeah, if you're in a position where, say, Pennsylvania could impose tariffs on, steel from a different state or whatever, you're not.
It's actually worse than that, David, because under the Articles of Confederation, that was basically just an agreement between the states. They were free to make other agreements if they wanted to.
Right.
They could say that Pennsylvania, let's see, what borders Pennsylvania? Pennsylvania, Maryland, and Virginia are going to wage war on New York.
Yeah.
We're going to enter an alliance so we can wage war on New York. And they're allowed to do that. That's not prohibited. I mean, I guess there are conditions in the Articles of Confederation about when you can declare a war.
Yeah.
But even then, there's nothing that's not binding.
Yeah, there's certainly no mechanism by which you could say, you know what, no, you can't do that. They could just decide to do it, and then everyone else could just sort of say, well, we think you shouldn't.
Yeah, so that's, you can see how that would be a very unstable system, because it happens very commonly that states do not agree.
Right.
So what do you do when you resolve differences between states? And this is where our next one comes in, and that's going to be bicameralism.
Yeah. And this is also, we've talked about this before too, but there's a direct link between the bicameral system. That means two houses for those, who aren't brushed up on their, I want to say Latin. Yes, Latin.
It doesn't mean two cameras?
No, because...
or two camels?
Camera, as in a photo camera, actually means chamber. That's what the root word is. It's like, a chamber where... But before we amended the Constitution again and changed the way the Senate was elected, it was very clear how the House of Representatives was representing the interest of the people and the Senate represented the interests of the states, because the state legislatures directly appointed senators. Now we elect
and
both.
Still, and you do still get some of that, even under the present system modified by the 17th Amendment, because, remember, under the Articles of Confederation, it was basically one state, one vote. They could send delegates, but each state had the same representation. Obviously, a pretty bad system if you're trying to make any kind of decision that's going to be for the whole of the American people, because those states are very different sizes.
Yes.
But it's also a horrible idea to just have proportional representation, because that doesn't give the states any voice or any say in government, which means you just have a national government at that point. There's no actual state government that's closer to the people and represents the needs of the people in that area more effectively. Yeah. So what we end up getting is a bicameral legislature where, even today, 2 senators per state, representatives based on population. Works pretty well. Makes sure that both kinds of entities are represented in our government.
Yeah, and it gives you, I think, even just sort of on the practical level, we've been talking, that's a bit about sort of the theoretical side, which is very important, but even just sort of pragmatically speaking, one of the issues with the Articles of Confederation is, unless, something was absolutely uncontroversial, you were basically never actually going to be able to pass legislation, because it required the majority of states to endorse it, and in some instances, a supermajority of states.
It's also, one of the real things that you'll see that our Constitution is on guard for is the idea of tyranny of the majority.
Yeah.
We believe that rights should be protected even if the majority of people want to take them away from you.
Exactly.
The Articles of Confederation had a real tendency toward tyranny of the majority, and that was exactly the sort of tendency that could very easily result in civil wars. Because if you got 7 of 13 states saying something, even if they're the smallest 7, that might be, I don't know the numbers, but that might be like 25% of the population, perhaps even less.
Could be, easily.
Deciding what's going to go for everybody else.
Right.
That's obviously going to result either in some members leaving the Union or worse, in a civil war. Those are pretty much the only consequences that you'll get from that. Yeah. So our Constitution, by having a bicameral legislature, directly avoids this tyranny of the majority issue.
Right. And so you get, on the one hand, it is possible to make decisions that the majority of the people want, even if the majority of the states are, maybe iffy about it. But on the other hand, it's not just dead easy to pass anything that you can get a bare majority to agree to on a given day. And that's, I think, one of the genius elements
that's the
of
Washington
Constitution.
story to Jefferson. Is why do you pour your tea into your saucer? Why? To cool it.
Exactly. Yeah. Passing through two different deliberative bodies, even, regardless of what they are, is often a good way to prevent, just sort of some harebrained scheme from winning the day.
Yeah.
But particularly when they represent different interests and do it as elegantly, in my opinion at least, as they do in the Constitution.
We're ideologues here. We definitely believe in we do like purity of principle. If you're listening to this and you're saying that sounds like a lot of compromise and you don't really like compromise, it doesn't really sit well with you, we get it. Believe me. Mm-hmm. We're of a similar disposition to that. But also, please trust me on this one, it's way better to have a government that's the result of compromise. Because even a great idea implemented too quickly against the will of 49% of the population is very, very quickly going to destabilize your society.
Absolutely. Yeah, no, there's no question about that. And, you get ways of sort of ensuring that decisions are made have at least reasonable consensus about them under the
and they're usually going to be, moderated versions of things. They're usually not going to be the fullest expression of whatever idea it was. They're going to have give and take.
Yeah.
That really is a good thing. You want slow change. That's Edmund Burke again. Read Edmund Burke's Reflections on the Revolution in France, lexrex.org/store. But that's really one of his main points in that is the idea of slow and moderate progress. He's sort of known as the father of conservatism, and I think conservatives today could do well to learn from him because he's all about progress. He's a progressive in the strictest sense, the old sense of the word.
Yeah.
But he doesn't believe that you ought to throw out everything and replace it with something that you made up.
Yeah. I think the key element, both in his mind and in large part in mine as well, is you want to keep contact with the past in some way. Keep contact because, the past is going to be basically your touchstone. That's what you've actually experienced. And so you need to keep in contact with that so you understand how the changes you're implementing actually work before you just change everything. And if it fails, it's going to fail spectacularly.
It's like Barry Goldwater's definition of a liberal.
I don't think I know that one.
Oh, it's a liberal is somebody who wants to try something that has never worked before.
Yeah, no, that's that's fair.
Not saying our opinion on that, but that's sort of where he's going with it. Edmund Burke is a conservative, so that's something we can talk about. But one of the points that he makes, a very salient point, I think, is sure, like he's talking to the French here, who obviously didn't like their king too much, didn't like the past few generations of leadership, so they were kind of inclined to throw it out. But his point was, if you don't like the last several generations of leadership, just go back further. They'll have all the more the pomp and importance in your imagination because no one's met them.
Yeah.
I like it because he's very utilitarian about it, but he's right.
Yeah.
Anyway, that's sort of a tangent, but we had one last point we wanted to talk about with respect to the Constitution's corrections of the Articles of Confederation, and that is the idea of enumerated powers.
Yeah. And we harp on this all the time. Yeah.
Yeah, we talked about this briefly last time when we talked about Articles of Confederation, but under the Articles of Confederation, the powers of Congress were theoretically unlimited.
Yeah.
It could do basically, within some very loose limits, but it could do basically whatever it wanted as long as the majority of the states agreed to it.
Yeah.
That's not true under the Constitution, because under the Constitution, the only powers that any entity in government has are those that are mentioned by name in that document.
Yeah. And I think, there's a few important things to note about that. One is that I think that's a direct consequence of the fact that, as you mentioned, the Articles of Confederation didn't propose that this national government derived its authority from the people.
Yeah.
I think it's clearly recognized if you're getting power from someone granting it to you in a very concrete way, a person, a group of people doing it, then you get that it's only what they tell you can do with it that is legitimate. As opposed to the Articles of Confederation, it's just sort of, we know the states have certain powers, and then whatever they can agree to among themselves will do, because, that's the whole design here. You don't have that sort of innate break on it.
So they fixed it. Turns out that our framers were pretty good constitutional mechanics. They were able to make a system that worked, and that's the Constitution we have today. Oh, one last point I wanted to mention is the appropriation of new lands for states. Alexander Hamilton goes on at great length about this in Federalist. I believe it's 6, 7, and 8, but it might be 7, 8, and 9. I'm pretty bad with numbers. But he goes on about this, talking about how the acquisition of new land is absolutely ripe for conflict under the Articles of Confederation because it's not... states can just say, this new land is ours now. If they border it and they occupy it, they can say it's theirs. This was remedied under the Constitution because there's explicit means by which new territory is adopted under the Union and under which states can become states or appropriate new territory. So, yeah, that's another thing that was fixed. That pretty much concludes what I have to say about the way, I mean, there's a lot more we could talk about, but we do have a time limit. We're not using metric hours. So, yeah, that's the Constitution and how it improves upon the Articles of Confederation.
Yeah.
Anything else, David?
I think one thing I meant to bring up earlier when we were talking about the executive, and I think it bears mentioning, is when you have a government that has basically only a legislature or a very overpowerful legislature, no one is around to tell them when something is unconstitutional, however defined in that system.
Point.
And, that's basically the function.
That is the problem in Great Britain.
Yeah.
I mean, they had a civil war over that.
Right. And when the king had
that was the king, but
yeah. Fair.
But legislature thought it was their job to tell him he was acting unconstitutionally, and he said, you can't tell me that. So
yeah. And in the sort of relatively recent past, that was sort of the understood function of most monarchs in constitutional monarchies. They didn't really take a lot of active part, but they were around to tell the legislature when it was overstepping its bounds. You need somebody
Cromwell
like that.
did a lot of that, even though he wasn't a monarch.
Yeah. But you need somebody like that, and that's a lot of what the president is for. That's why strong veto powers are a good thing.
Yeah. All right, gather around, kids. It's time for everybody's favorite and most exciting section of this podcast, Captain Kangaroo Court, where we look at some of the ridiculous things that have been done either in courts or at least in the law, or
tangentially related to the law.
Or tangentially related to the law, and talk about those. Kids, it's a great learning opportunity and your favorite show on the internets. So
yeah,
it's George Bush's internets plural. So anyway,
did he actually
Captain Kangaroo Court?
Did he say that? I don't remember that.
Yeah, he said, "I've heard rumors on the internets."
Huh. I always assumed that was something that just sort of developed as sort of an organic irony.
No, that was a Bushism.
Okay.
Yeah.
You learn something every day.
Yeah.
Anyway.
So, David, what have we got today for Captain Kangaroo Court?
Well, as promised last week, we are going to talk about the Roving Judge Gang of Indiana.
Oh, yes, the Roving Judge Gang.
Yeah, and so...
And I've got one, David. I actually surprised you. I've brought one, too.
Oh.
Also about a weird judge. So, we're staying true to the spirit of Captain Kangaroo Court for sure.
Anyway, so what I did is I found the NPR article reporting on this. It's from 2019, and we'll start just by reading the headline.
Less boring, David.
3 Indiana judges suspended after White Castle brawl that left 2 of them wounded. And some of these details I had forgotten. But anyway, so...
Well, are they brawling with each other or brawling with somebody else?
No, brawling with somebody else. But
that's what I thought. Yeah, they were. Somebody was assaulted by judges.
Yes. Well,
inebriated judges, right?
There's a little bit of back and forth here, and who escalated and who we'll get into it. We'll get into it. Here's a few things to note. First of all, so they were in town for some kind of judicial conference, right? And it's the day before it actually begins. They're out, celebrating.
Generally, judicial conferences are fairly sedate affairs.
You would
guys.
think.
They're not generally the sort of event where everybody boards up their windows beforehand. That's when you hear the judges are in town. You don't think there's going to be a lot of property damage and so on and so forth. Yeah. I'm not sure if you guys knew that, but that's fun fact.
But evidently, a group of these judges in town decided to let their hair down a bit and, have some drinks. But this group took it quite a bit further than that. Quite a bit further than that for these 3 specific judges. So this is another thing I had forgotten. They started by trying to go to a strip club called the Red Garter at 3 a.m. and they found it closed. So they're already up past the strip clubs. So that's
Are all these judges men?
No, it's 2 men and a woman. 2 men and a woman.
All right,
so that was, make of that what you will, I guess. But
at least they're equal opportunity offenders.
yeah, so having failed to get into this strip club, they decide to do the logical thing and go to White Castle. So they go to White Castle, and there in the parking lot, one of the judges, it's the woman, and anyway, I guess we'll probably leave the names out of it. No need to.
You're imagining. So I want to make sure everybody has the right mental picture here. They're wearing the robes the whole time, right? And some of them probably have the wigs with the curls, or no?
No, but I prefer it, and so we'll go on that assumption.
Yeah, we don't actually do that in America. Another fun fact. Actually, the only place that does require that now is Hong Kong, interestingly. Yeah. Which we can get into another time, but probably didn't have those. But we're going to imagine them with the wigs, okay? And they're each carrying a gavel.
Sure. Yeah. If that helps you picture this, then fine. But anyway.
Yeah.
So the 3 of them clearly, inebriated in this fast food parking lot. When one of them...
White Castle. Not just fast food, it's White Castle.
That's true. It's
which is not in California. I've not had it, but I understand the reputation is...
I've been there once, and the burgers looked kind of gross to me. I know a lot of people like them. They're very greasy. They're very sort of small, and it's a very particular thing. I know some people are fanatically loyal to them.
But they're kind of regarded as, bottom shelf fast food. Even if they're, they might taste good. But.
Yeah, it's not high quality meat. And I didn't have it in me to actually try the burgers. I got like a chicken sandwich when I was there, and it was very mediocre. So anyway, that's my... Oh my
gosh, David, really? You went to White Castle? You didn't get one of the burgers?
No, I didn't think my stomach could handle it.
Wait a second.
Shame.
Are you going to play the...
Shame.
Oh, okay, all right. I thought you were going to... thought you were going to play the guillotine sound effect and imply that I deserve the death penalty for that, but... All right, well, okay, that's... debatably it's shameful to eat them, but we'll leave that aside.
Not if you're going to White Castle, though.
Well, I didn't, We're spending too much time on this. Anyways, they're in White Castle. They're in White Castle parking lot, and one of them, and now interestingly, I had forgotten this, it's the woman, quote, raised a middle finger at 2 men yelling from a passing SUV. And I had also forgotten this detail.
Insulting their wigs?
Probably. We can assume that.
Yeah.
Not actually, but we'll pretend. I had forgotten this detail.
So she finds them in contempt of court, right? Or at least in contempt of those judges.
Yeah, in contempt of their personal authority.
Uh-huh.
But I had forgotten this, too. It ends with one of the judges being shot by one of these men.
That's right.
I had completely forgotten about this.
Boy, can you imagine that guy when he found out the person he'd shot was a judge? Gosh, that must have been horrifying.
But, so, absolute chaos. I can't even... We've talked about this before. When you first told me about this, we had a long conversation about this. And I said I couldn't think of anyone except... And, you corrected me on this point. We'll get to that in a minute. I said I can't think of anyone more sort of ill-fitting for this kind of story, more shocking that a judge would do this. And I think I said, except for maybe a senator. But you correctly pointed out it's actually much easier to imagine senators doing this kind of thing.
Oh, yeah, way judges. Easier.
Because you get some of these senators, like a certain, let's say Schmeddy, who get into sort of hijinks.
Yeah. But I said, initially I thought maybe a pastor, but then I thought about it, anybody can be a pastor. Not all denominations require you even have a degree to do that. Or that you be ordained. Anybody can be a pastor. There's some basic threshold things you have to satisfy to be a judge. Yeah. There's a lot of, at the very least, there's a lot of hurdles you have to jump through. You have to have at some point organized your life so that you have fairly meticulous habits,
you
that
at least
work
got
fairly
through
hard.
Law school and passed the bar, and presumably, were
at least
a pretty decent lawyer for an extended period of time, likely at least.
Or at least if it convinced a lot of people that you were a pretty decent lawyer for a couple decades.
Right, and even if that's all a sham, it's one that would take a lot of discipline to maintain. Yeah, exactly.
Yeah.
It's hard to think of more unjudge-like even there's the expression sober as a judge. Evidently not.
Not a White Castle judge, though.
No, not at an Indiana White Castle. And the Indiana judiciary agreed with that, apparently, because the Indiana
I think they
Supreme
disbarred
Court,
them all, didn't they?
They at least suspended them. But the Indiana Supreme Court said that they, quote, discredited the entire Indiana judiciary, which... Yeah, that seems about right. By
that's
having
right.
engaged in judicial misconduct by appearing in public in an intoxicated state and behaving in an injudicious manner, which, you know.
That's injudicious. We get the word judicious from judges.
From judge, exactly. So, yeah.
Yeah. All right, I've got another one with a crazy judge. Wait, is that it? Or?
Yeah, I think basically, I wanted to say, we talked about this last time. I think at some point we should try to put out a t-shirt that has something to do with the judge gang. I'm on record as endorsing that. I'd probably buy one if we did it.
Yeah, we should. If somebody wants to make a design and submit that to us, we'll have a contest.
Yeah.
You know, winner. I don't know what the winner would get.
A book and one of the T-shirts when we print them. Maybe, who knows?
Yeah, it's a $30 value. Yours for spending hours of time creating a logo. Okay, this is actually something that our law firm received.
Okay.
A couple years back. This is also from 2019. Not a great year for judges, apparently. This is from a judge who is no longer sitting on the bench. She was actually removed from the bench subsequent to this. But this is the craziest. So you submit most filings to the court electronically nowadays. And if there's some kind of defect in the filing, like maybe it says the wrong court name, or it does any of the local rules it doesn't follow, maybe the font's too big, or things like that, judges reserve the right to kick it, reject that, and then make you refile it. It's not a big deal when it happens. Happens a lot. But usually they give a reason why something is rejected. And this is a rejection notice that we received from a particular judge whose name will not be mentioned.
Yeah.
But what it says is the electronic order that you uploaded on 4/12/2019, and then lists the case number, has been rejected. The reasons for rejecting is /R as follows: formatting errors. And then it says, please see the court's website under Judges tab, and then it says the judge's name, that instruction/procedures tab for sample pleadings with the correct format and preferred content that incorporate the requirements in the LBR and court manual. So it's saying, you look at the local rules, look at this judge's particular rules that apply just to this particular judge, and see what she wants you to do. Well, then they're also very helpful because they list the specific problems that we had. Then it says, please use only one font, Arial numbers and Times New Roman text. Left margin equals 1 inch. What that's referring to is the numbers that go down the side of the page that number the lines in a document.
Yeah, so you can.
We were using the court's form. We did not change the font in that. That's the form the court requires. In fact, I've always hated that form specifically for that reason, is that it's got two different fonts. But we're not allowed to use a different form from that. So anyway, next, that's not the more egregious thing here. Here's the one that I really want to draw your attention to. Plain English only. No antiquated language.
Right,
Maybe you guys don't like it when lawyers use antiquated language. I know a lot of people don't. So what are the examples of antiquated language that she uses? Hereby. Herein. Adjudged. Whereas. Therefore. Upon.
Upon?
Shall be and hereby is.
You've got to be kidding me. Upon. Really?
Therefore.
Okay, yeah. Like, some of those I can, I putting myself in the shoes of someone who's very unfamiliar with this sort of world, I could say, oh yeah, hereby sounds sort of stuffy, and herein, yeah. Therefore and upon are like, that's like probably like a 5th grade vocabulary word. I think therefore. Upon is like, 2nd grade
6-year-old.
maybe. Yeah. Like upon is, wow. That's one of the most basic ones.
I guess, anyway. What should we have said? So what would you use instead of upon? Like if we weren't using that word, what would you use? This was based upon the ruling in XYZ. What would you say instead?
I guess just on, based on.
This was based on?
Yeah.
That's not technically correct because it's not like on it, it's based upon it. That's,
but and
and then that's the broader point here is there's a reason why lawyers use legalese, and it's not just so that things are hard to read and complicated. Most of these words are logical positional words,
right?
And they're very necessary when you're trying to juxtapose one concept against another. You might say, well, what were the ones she didn't like?
Herein, hereby.
Herein.
Yeah.
So we might refer to something as occurring herein because it's a very long description.
Right. Yeah.
Whatever the document is. So, the one herein referred to is what you would say instead of saying the name of the document again, because you got to be specific in each reference. You can't just use short names for things unless you've defined them as short names. So that sort of helps you to shorten that. A lot of them are logical positional words.
Yeah, you could say, I guess, the thing referred to in here, and by here we mean this document you're currently reading.
Or we could say this there, you know, or that there, rather. As referred to in that there motion.
Yeah. Yeah. You know, I guess if your options are you sound a little bit sort of uptight and old-fashioned, or you sound like Jed Clampett, you should probably opt to sound a little bit stuffy.
Yeah, so this was the craziest rejection notice I've ever received. I actually had it framed, and I'm going to put it up on the... Well, I'm actually... That's a lie. I haven't gotten it framed yet. I've been meaning to get it framed since this happened. I'm going to get it framed. I'm going to put it up on the wall because it's one of my favorite things I've ever gotten. I think it's absolutely hilarious. And I'm really glad we're doing Captain Kangaroo Court because I can talk about it. But a little bit more about this judge. So you guys may know my dad's a lawyer. That's the Haberbush LLP practice. That's his practice. And this was a motion that was submitted from that firm. So a past case that we had was in front of this same judge. And granted, our client was kind of a crook. We didn't know that when we took him on initially, but he was not the greatest guy. He was kind of dishonest. This judge hated him, hated him with the passion, and didn't want to give him his legal due, what she was legally required to give him, because she disliked him personally, which is judicial misconduct of the highest order.
Oh, yeah.
Really glad she's been removed from the bench now. She was a pretty terrible judge. That's actually, after she got removed from the bench, she had the gall to send us an advertisement in the mail saying hire her as a mediator. Because you're not a judge anymore, you can still mediate stuff.
I remember you telling me about this, yeah. Oh, I forgot that was that same lady.
Yeah, we saved that too. I'm going to get that framed too.
There you go. Yeah.
Anyway, in this case, our client's kind of a crook. She doesn't like him. She's really, really mad at him one day, and I forget what's happened. I don't remember all the details, but she says, I'm going to sanction your client to my dad. My dad's at the hearing. My dad says, well, look at the statute. The statute says there's no legal authority to sanction my client. She's like, I'm going to sanction your client anyway. And my dad, you literally can't do that. You don't have the authority to do that as a judge. She fumes off of the bench, leaves, goes into her chambers without saying anything, and everybody just waits there for about 20 minutes until she comes back out, goes back behind the bench, sits down, still fuming, kind of throws herself down in her chair and says, I just read the statute and it says that I can't sanction your client, but it does say right here that I can sanction you, talking to my dad. You can sanction the lawyer on behalf of the client. My dad looks her square in the eye and he says, yeah, that's true. You have authority to sanction me if you want to do that. She says, but I don't have any grounds to sanction you. He says, yeah, that's also true. And she says, so you can pick. I'm going to sanction you or I'm going to sanction your client. My dad says, well, you have legal authority to sanction me. You don't have legal authority to sanction my client. You got to sanction me. She sanctions every lawyer in the firm.
Wow. Yeah, that's...
If that isn't a kangaroo court, I don't know what is.
Yeah, and that's not probably quite as, to use the same sort of quasi-pun, injudicious as the drunken judges roaming around getting into gunfights.
No, not quite, but it's from the bench, which I feel adds something.
Yeah, that's pretty close. That's pretty ridiculous. You're just, I'm going to hit somebody. It's got to be somebody. Yeah. Somebody's got to pay.
Blatantly says, I have no grounds to sanction you. And he says, yeah, that's true. She's like, I'm going to do it anyway. Blatantly doing something she admits she has no grounds for doing.
Yeah, well, someone had to answer for her frustration and anger in that moment. I guess it was
you guys may think judges are bad. Most judges are not like this.
Yeah.
And the ones that are do get removed from the bench. She eventually got a very high-profile case, which I won't mention. That sort of put more of a public spotlight on her. And that's what ended up getting her removed from the bench. But we all laughed when we saw that case was going to be in front of her because it's like, yeah, that guy's not getting a fair trial. But,
yeah. Anyway, all right. I think we're actually a bit over time, so we're probably going to have to call it there.
Anyway, kids, that's all for Captain Kangaroo Court. We hope that you've learned a lot about our judicial system and the way that judicial officers behave, or rather,
shouldn't
misbehave.
Yeah.
And, we'll see you all again next week on our next episode of Captain Kangaroo Court. If you do have submissions for that, you can send them to info@lexrex.org. That's info@lexrex.org.
Yeah, and we have received some submissions. We're still, we're preparing to sort through those. You will likely hear some of them, but, hang tight. Anyway, thanks for listening, and we hope that you'll listen again.
Yep, that's all for today, folks.